From the Sunshine State, this is Tampa Bay's Tan Talk.
It's time for FLALAW, brought to you by the personal injury attorneys of Perinick, Caulfield, Averill, and Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
Good evening. It is Tuesday at 5 o'clock, and that means we are here live in the studio for FLALAW on the radio. My name is Matthew Noyes, and I'm one of the attorneys at the law firm of Perinick, Caulfield, Averill, and Noyes, the oldest personal injury law firm in Tampa Bay. We started back in 1955, and 71 years later, we're still going, trying to help people after they get hurt in car accidents, trip and falls, work injuries, and even Social Security disability matters. We put on this show for you to have your legal questions answered. It's a community service that we do. It's sometimes people have questions they have one or two questions to ask a lawyer, and they don't really want to have to set up a meeting to talk to the lawyer. And so that's why we have this show for you. There's three ways to get in contact with us. One way is the easy way. Give us a call at 727-441-3000. The second way is through Facebook Live. You can just jump on our page at Perinick, Caulfield, Averill, and Noyes Injury Lawyers. You can see us in the studio and type in your questions there. Or the third way is the YouTube channel. Just jump on our YouTube channel, and Ed on the other side of the glass will let us know what your comment is, and we'll be able to attack your questions or your comments any way you want to present them to us, by telephone, Facebook, or even YouTube. Again, I am Matthew Noyes, but I am not here by myself. I have a very fine local attorney here, a friend of mine that has agreed to spend an hour of his time as well to give back to the community and to answer any questions that you have about, I'm going to call it estate planning, but it's more than that.
It is more than that, yes.
And this is Adam Rauman. Adam, thank you very much for joining us again. We appreciate that.
I appreciate the opportunity. Always fun to be on the show.
Yeah. So, Adam, why don't you tell our listeners just a little bit about your background? I know you were a financial advisor as well as an attorney. And so why don't you tell our listeners just a little bit about yourself and what type of questions that you can answer tonight and what kind of issues we're going to be talking about tonight.
Sure. So I spent 15 years as a financial advisor. I had a Series 7, 65, 63, and I still have an insurance license, life, health, variable annuity. I've been an attorney now for 15 years, and I do estate planning, which is wills, trusts. I also do probate, do some real estate law, and a lot of business law. When it comes to business law, I help corporations get set up. I help corporations in corporate sales, transitioning through succession planning, and pretty much anything on a business side that you might need, from a contract, a lease, or anything else with regard to a corporation.
That is a lot to talk about.
It is.
So we always have all these questions and all these things to talk about, and we run out of time because we're only here for an hour. But I do appreciate you talking about it. It's very, very important to know. I mean, because it's not like a personal injury case where you may never need a personal injury attorney if you never get hurt. True. But you're always going to need somebody that can preserve your assets when you're living, and continue to preserve your assets for your family once you pass away. And so it's very important people contact you or attorneys like yourself. You can't escape it, I don't think.
No, there's only a few things that are certain in life, and that's death and taxes. So
That's right.
That's coming. So if everybody that needed an estate plan was getting an estate plan, every attorney that does estate planning would have a line standing out our door. So there's a never-ending supply of estate planning clients, because a lot of people like to sit back and not talk about things that would happen if they get sick or if they pass away. They just want to sort of stick their head in the ground and ignore it. I think the oldest person that came in my office, she was 98 and finally decided it was time for her to do a will. So
wow. Well, good. And your law firm is called?
My law firm is Preservation Law Firm.
And why do you call it that?
Well, because I'm looking to preserve people's assets while they're alive and transfer as many of those assets as we can when they pass away without having to go through probate. Even though I do probate and I really like probate because I make a lot of money in probate, when you come to my office and we talk, I'm looking to avoid probate. Probate for the business, probate for the other assets that you have, because probate can be expensive and time consuming. If you're setting up a proper estate plan and you do proper designations on those assets, you can avoid those sometimes unnecessary expenses.
Yeah. What are the 3 most common estate planning mistakes that you see?
First one is not getting an estate plan.
Right. I was going to say, and how can listeners avoid that? I know how to solve that problem. That's pretty good.
So a couple of the other common mistakes you see is thinking you only need a will and you don't need a trust. A lot of people think that a trust is for rich people, and a trust really doesn't have anything to do with wealth. It has everything to do with probate avoidance. So that's another mistake. You'll have just a will thinking everything's going to be okay, and then you end up finding out everything's going to go through probate, and your family's like, why? I had a will. The will still has to go through probate. So if you die with a will or without a will, you are going through probate. You die with a trust. And that leads us to the next most common one, is not having the trust designated to pick up the assets. So they'll have a trust, but they'll leave the assets in their name. They won't have a beneficiary designation on it, which means I have to gather the assets, put it through probate to get it to the trust in order for the trust to make the distribution the way you want it done.
Oh, okay. That makes sense, because I always hear that it's wills versus trust, but in some situations it's wills and trust that you need.
It's a will and a trust. So if you have a trust, we do what's called a pour over will. It's just a simple term for, hey, I forgot it, grab it, put it through probate, give it to my trust, and let my trust make the distribution from there.
And we talk about avoiding probate. What's the benefit of avoiding probate?
Well, everyone thinks probate is bad. It's not all bad. I'll talk about the negative things first. The probate can be expensive. So the Florida statutes outline a guide on what people charge for probate services. It's not a statutory mandate that you charge those fees, but it is a guide, and most attorneys follow those guides. And the guide is the same for both your personal representative. Everyone's familiar with the term executor. Well, in the state of Florida, we use the term personal representative because an executor refers to a man and an executrix refers to a woman. And Florida said, forget it. Everybody can be a personal representative. Okay. That's what we're going to do. So when you have probate, most probates are formal administration. That's the long one where it takes about 12 months. The statutory recommended guidance says 3% of the first $1 million. It's 3% for the attorney and 3% for the personal representative. So if you had your cousin who's not inheriting from your estate set up as your personal representative, your estate could be looking at losing 6% of the value of the estate. So it can get expensive really quick. And then you have the cost of probate. So you have to get probate bonds. The court filing fee is higher. There's a number of other things. You have to do a publication to a notice of creditors. You have to send out those notices. So those expenses can easily go somewhere between $800 and $1,000 in cost alone.
Oh, okay. And the time involved too, right?
The time is going to be anywhere between 9 to 12 months on average. So it can be a lengthy process. Now, that doesn't mean you can't get your hands on any of the assets. That's just the length of time when you open the probate and get it to the closing point at the end.
Right. And if I understand correctly too, one of the drawbacks of probate is that it's all public.
Everything that goes through the probate process is a public process. And so you don't necessarily want to do that. Your will gets filed with the clerk of court. Anybody who wants to see what your will says can go down to the courthouse and get a copy of it, and they can see what the will says. The trust is going to be private. So that's one thing to do, is have a trust so what you have in your estate remains private, because in a probate, we have to file what's called an inventory. Now, the inventory lists the value and the specific assets. So it says the bank accounts and the values of the bank accounts and the brokerage accounts and all those things. Now, in the court records, they do redact that, but it's still in the public record. You can still see the total value of what's there, even if you can't see the specific listings of the individual assets.
Yeah, and in today's social media days, that information, they want to get that information and post it and let everybody see it as well.
Exactly. So you can see you have 6 beneficiaries in a estate that's worth $5 million. Great.
Yeah. So someone's going to be doing something.
But probate isn't all bad.
I'm going to ask you that.
You can have a trust and you can avoid probate, and your beneficiaries may elect to do a probate. The reason they would elect to do a probate is because we can get rid of creditors that way. So in the state of Florida, you have a 2-year creditor window. After you die, anybody and everybody that you potentially owe money to has 2 years to make a claim against your estate. And if your estate doesn't have any money, and just to clarify, an estate is whatever is in your name when you pass away. So if everything goes to your trust, your estate may not have anything. Your trust is also there to pay those debts. So medical bills, credit card bills, anybody else you owed money to, all those debts have to be settled. Well, there's a 2-year window with the creditor period in the state of Florida by statute. We can shrink that down to 90 days by publishing a notice of creditors, but we have to open up a probate in order to do that. So we open it up, we can take your 2-year window down to 90 days. And for the known creditors, you owe Dr. Smith some money. We send Dr. Smith a creditor's notice. He has 30 days to make a claim against the estate. So by shortening those periods, we may be able to get rid of some of the debts that you had out there. So it's not all bad.
So if doctor doesn't submit his claim within the 30 days, his claim is waived?
His claim does not get paid.
So that seems to be a pretty good benefit for the probate process of it.
It is one reason why people who have a trust, their kids may elect to do a probate, just to run that creditor period to make sure there's nothing in the woodwork that they weren't aware of. And then you get a bill from Dr. Smith, you're thinking insurance is going to cover it. You can send him a creditor's notice and see if he files a claim. Maybe insurance is paying it, maybe it's not. But that probate process is going to help make sure that the bills get settled, because once you send them the creditor notice, once that window falls through and that 30 days is done, their claim is forever barred.
And you said something that I thought may be a misconception to many of our listeners, and that is, just because you have a trust doesn't mean that you're not responsible for the decedent's medical bills.
True.
Or other bills.
So the trust has language written in it pretty early in the trust that says, if there's not enough money in my estate, my trust is there to pay those debts that I have in my estate. So typically what you'll see is a husband and wife own everything joint. Husband passes away, everything transfers over to the wife. The husband's estate has nothing. And if there's nothing in the trust, there's nothing to pay those bills from, because the husband's medical bills are the husband's medical bills. Then when the wife dies and everything transfers over to the trust, there is money to pay those bills because it all moved to the trust, and the trust is there to settle the estate assets, or the estate debts, excuse me.
But if the wife dies more than 2 years after the husband died, does that matter? Or?
So the husband's debts are always just the husband's debts. If there's not any money in that trust at the time the husband passes away, there's no money to settle those debts. So typically joint owned assets go to the survivor. So you pass away, everything belongs to your wife. You don't have anything, so there's no money to pay those debts from. If money starts going into your trust, then there technically is money to settle those debts with.
Okay.
So typically when I set up things with beneficiary designations. Those beneficiary designations go to the trust upon the death of the various settlers. Most settlers, which are the people that set up the trust, those individuals typically own the assets joint. So the assets don't typically go to the trust until the last of the two of them die.
That makes sense. So listeners, if you're just jumping on FLA Law on the radio, that's what you're listening to. I'm Matt Noyes with the law firm of Perronick, Caulfield, Averill, and Noyes, the personal injury law firm here in Clearwater, and the oldest personal injury law firm in Tampa Bay. We started in 1955. I've been helping people ever since with their claims for auto accidents, slip and falls, work injuries, and other types of personal injury matters. But I'm not here alone. I also have my friend and very smart colleague, Adam Rauman here, who's been educating me and hopefully you all as well on estate planning and steps to preserve your assets for your family once you pass away. So Adam, again, thank you. And if callers, if you have a question for Adam or even for me, give us a call at 727-441-3000 or jump on Facebook Live at Pernick, Caulfield, Averill, and Noyes Injury Lawyers. We'll be happy to tackle the questions that you have. But Adam, before we take any calls, I did want to talk about something that I thought was very important, and that was talking about titling the property properly. I've seen. I remember from my real estate class in law school many decades ago that all I learned was that I'm not going to do real estate, but also I learned, joint tenancy by the entirety and other ways to title property. Can you tell our listeners the benefits, the ways to title property, and why you would title certain property in certain ways to preserve your legacy?
Absolutely. So when we're talking about property, we're not necessarily talking about real property, which would be like your home. We're talking about any type of property that you would have, your bank account, your brokerage account. Even if you own a privately held company, if it's an Inc., you own stock, that's property. And if you own an LLC, you own membership certificates. So there's different ways you can own that. You can own that as an individual. You can own that joint with rights of survivorship. So you and I could have a rights of survivorship account. If you pass away, I get the money. If I pass away, you get the money. That's really easy. But then for husband and wives in the state of Florida, I say husband and wives, it's just married couples. You have what's called tenants by the entireties or joint tenants by the entireties. It's more commonly known as tenants by the entireties, but it's the same thing. The entireties, what that means is it's 100% yours and it's 100% your spouse's, which makes it unique. So you and I having a joint account, if either of us got sued, they could figure out how much in the rights of survivorship account was yours and how much was mine, and they could take that money out of the account. But when you have tenants by the entireties, and I'm only getting a judgment against you and not against your spouse, if all of those assets are tenants by the entireties owned, I can't go after any of those assets because they're 100% your spouse's, and I'm not suing your spouse. So it's 100% protected that way. So when you own things, tenants by the entireties between spouses, it automatically transfers just like rights of survivorship over to the surviving spouse when you pass away, but it's an extra creditor protected tool. When you open up an account, whether it's a bank account or it's a brokerage account in the state of Florida, it's an assumption that it's been opened up as tenants by the entireties. But the easiest way to know that it's that way is when you're married, you open the account together. If you own business assets, we can retitle those assets and change those assets to be owned as tenants by the entireties. And we can do the same thing if you need to add your spouse. You owned a house by yourself, got married, and want to add your spouse to the house, we can turn around and do that. One of the other things that you try to do is we put beneficiary designations on those assets so we can help avoid the probate process at a later date. But if you're married and can own something as tenants by the entireties, that is most often the best way to own it, so we can get an additional layer of asset protection into place.
What's the risk of not if you're not married but you have a joint account? Sometimes parents say, "Oh, I'm going to put son Joey on my bank account," and what is that? Is that smart to do, or
it's convenient?
It's convenient, but is it the smartest for preservation of the assets?
No, I think that's a liability, because if Joey gets in a car accident, Joey gets sued, and there's a judgment against him for more than he has in auto insurance, they go after other assets, and those other assets could be that joint account that you have with your son. So whatever percentage of that account the court decides is his, that money could be coming out of that account. So it's a liability. It would be better to have an individual account and list Joey as the beneficiary on the account than it would be to open up a joint account.
Yeah, because Joey could also take that money even if it's not his, because he's a joint account, right?
Exactly. So if Joey just had gambling debts and you didn't know it and Joey needed more money, go get the money out of mom's account and I'm on it. He didn't violate any law. He could take the money.
Didn't do anything wrong.
Exactly. So you can go ahead and take the money.
Great. Well, before we take the next question, we do have a caller on the line. Hi, Peggy. Thank you for listening to FLA Law on the radio. How can we help you tonight?
Yes. I have a condo, and I've got my sister and my niece's name on it, only they never signed it. And so now they're saying they need a new contract with their signature. I just cannot get them together to do that. My niece just had her third child in 2 years, and I just can't seem to do it. Can I just do a quick claim deed so in case I die, it will definitely go to them?
That's a very good question, Peggy. I think Adam probably has a few more questions to ask you to better answer that question. So, Adam, I'm going to lateral that right over to you.
So there's a couple things. It kind of sounds like when you own a piece of property, you have a deed. You can put other people on ownership by you giving them a deed, and you'd be the only one that signed it. If there's a contract the condo association's looking for, that sounds like it's part of the HOA system that they want them to be on that. I'd have to take a look at exactly what it is that you're talking about. But if you did a deed and you put you said your niece and your sister on that deed, they could give you quick claim deeds back so that they're no longer on the deed. We just
I want them to have it in case I die.
Well, that's great, but you don't really want them on that property deed, because if they are on the deed and they're not living in that property, they can't get homestead. You're getting homestead possibly on 1/3 of that property instead of 100% of that property. So if you get them off of the deed, they do a deed back to you, so you're the sole owner. We can then do what's called a ladybird deed, where you can make them the beneficiaries, or what would be even better is you draft a trust and we make your trust the beneficiary of that ladybird deed. So when you pass away, your condo will avoid probate. It will either go directly to your niece and your sister or into the trust, and through the trust, your niece and sister would get that. So that's a better way to do it instead of having them on. And do you mind if I go on a slight little tangent on homestead?
Sure.
Peggy, do we answer your question, or do you have any other questions on that?
That's all right. I think I'm set. Thank you very much.
Yeah, Peggy, hold on just one second, because I just want to make sure that it's clear. I think what Adam is saying, it's better for them not to be on the deed right now, but rather to be a beneficiary of the deed should you pass away. That's part of your estate planning.
It is a much better way to do it, because the other part of that, your homestead is protected from creditors. So if you get sued, they're not going to take your homestead. But if those two get sued, they can potentially put a lien on the house for their debt, and you don't want that. So there are ways that we can protect that, do exactly what you want to do, but get you in a much better situation than you have today.
All right. Thanks very much. Have a good day.
Peggy, thank you for listening. Adam, I think that was very helpful, because people think, okay, I'm just going to add them to it, and then they don't think the consequences of adding other people to their property. So I think that's very wise, and I'm sure Peggy sees how there's a different way to still get what she wants accomplished without risking herself or her sister and her niece.
It's a common thing to run across. If I just add somebody to the deed when I die, they'll end up as an owner, which is true. Right. That's exactly what happens, but they don't realize the pitfalls that come along the way along with that.
And there's another way to get the same thing accomplished
and give you the protection you need to get on your homestead. Because what people don't necessarily realize is homestead's a creditor protected asset, meaning if you get sued from a car accident, medical, or anything like that, they can't touch the house. But if you own just a regular piece of property that is not your homestead and you get sued, people can lien that. So when you add other people that aren't getting the homestead protection on that house can be liened to the interest of whatever that other person owns.
Right. Now, is there a limit to the amount of the homestead?
So there is a limit as far as what you're looking at inside city limits. If you had 25 acres in city limits, that's not going to be all considered homestead. I believe, I'd have to look it up to verify it. I think inside city limits, you're looking at 1/4 of an acre. Outside city limits, you're much more property you can use. Like, I think it's up to 160 acres as homestead.
And so I've heard that in Florida, people can have million-dollar homes, multi-million-dollar homes as a homestead, and people can't touch that.
So it's one of the reasons why you have people like OJ and Enron that all came here to the state of Florida when they ran into problems, because they can dump all this money into the house. The house itself is going to be a protected asset. All the money that's in there can't be touched, even if it's 100% equity. They can't force you to sell the property. There's only 3 entities that can force you to sell the property. That's the mortgage company, because you use their money to buy it. A mechanic's lien, somebody who worked on the property that you refused to pay. And then a taxing authority, the IRS, or property taxes. And that's where I want to
Surprise.
I want to go on a slight little tangent if you don't mind.
That way. Sure.
Okay, so the state of Florida, I'm sure you've seen Ron DeSantis is talking about eliminating property taxes on homestead only. And it's a very good proposition. We can afford to do it. You're going to see a lot of stuff in the news going on over the next several months, because they're trying to put it on as a ballot initiative for November of 2026. The problem we have is the Florida legislature, both the Republicans and Democrats, are standing in the way of getting what we need for homestead relief. When you're paying property taxes on your home, you are renting your home from the city and the county. You don't pay those property taxes, they can take your house from you. And we have a lot of problems with seniors not being able to afford those property taxes. They've lived in the house forever. It's all paid off.
They're on fixed income.
And they just can't afford to pay the ever increasing property taxes. So what I need everybody to do is call the various legislatures or email them and let them know we want one option on the November ballot. We want it to be DeSantis's option for elimination of homestead property taxes only. We don't want them to add additional fees to make up the difference. And we don't want them to increase the fees on the non-homestead properties. You're going to hear that they can't afford doing all that. Well, that's just not true. There's $1.5 billion in property tax waste just over the past year that Florida's Doge went through and found. They've got it out there. There's multiple videos online where you can see exactly what that waste is. Just to give you a couple examples, Orlando spent $400,000 to count existing trees with your property tax money. There is a Florida representative, I can't remember if she's in the House or the Senate, but she's a Hillsborough representative, and she has a charity that she makes personally $100,000 in personal income from your property taxes through her charity. And of course, she thinks we can't get rid of property taxes because she doesn't want to lose the income.
Oh, goodness. Yeah.
So they've done studies. They can eliminate homestead property taxes. The counties will have more than enough money to pay for things. We're sitting with a $15 billion surplus. So you do have small counties that only have homes and don't have businesses in them. And we can use that $15 billion surplus, and DeSantis already has it set up to pay those various counties that really would have a shortfall. But your major counties, your Hillsborough County, Pinellas County, Orange County, they're not going to have a shortfall, and they have more than enough money because they're giving a ton of money over to charities as well. So instead of paying for road fixtures and city services and police and fire, they're giving away money to various charities and a number of other projects that they really shouldn't be spending the money on. That's my little tangent. I appreciate the ability.
I like that tangent. And I'm going to have you come back in a few months, because I know that's going to be live and fresh going on in the news, as well as the legislative session gets going this week.
It's starting. I think we have 50 some odd days in that legislative session.
So I think that's important. I think it's important for people to hear that and understand a viewpoint, not from a politician. Not
from a politician, not from the media, from somebody who's actually paying property taxes and doesn't want to pay property taxes anymore.
And has seen many people that you represent having to deal with those situations.
Well, because one of the things that happened, mom and dad die, they don't realize that the property is going to have the property taxes reassessed, and those taxes are going to go up. Now, if it's not your homestead, it's still going to happen, but it's not. It's a very big shock when mom and dad had a $1,000 or $2,000 property tax bill, and all of a sudden the county decides to reassess it at today's value, and now mom and dad's house is worth $500,000-$700,000, and you've got a $7,000-$8,000 tax bill that you have to pay that you didn't anticipate.
That is shocking to many families, and that they're dealing with the loss of their parent, and then the taxes hit them in such a way. So I think it is important that our listeners take action.
I just had a client that actually called me. He got an assessment for $11,000 because when mom died, he didn't do anything about transferring the house. He didn't properly report her death. They kept the homestead status, which kept the taxes low. Then when the county saw that mom had passed away 4 years ago, they applied penalties and interest plus the 4 years of reassessed taxes on the property. So that's also a problem as well.
Wow. So that is important that when somebody passes away, they need to take action right away.
I would take action sooner than later. Is there a requirement to open up probate? No, there's not. But if you don't have that property titled in your name, you can't get you're not going to get homestead on it. You can't get property insurance. And this year wasn't bad. We got through in 2025 with no hurricanes, but 2024
knocking on wood there, so
2024 wasn't so good, and who knows what's going to happen in 2026. If you have a property that doesn't have property insurance, you could have issues.
Yes. And you're listening to FLA Law on the radio. This is Matthew Noyes. I'm a personal injury attorney with the law firm of Pernick, Caulfield, Averill, and Noyes, the proud presenters of FLA Law on the radio every Tuesday from 5 until 6. We are here live, and then when we're not here live, but you still have a question regarding a prior episode, you can easily find us on any of your podcast channels. We are on Spotify, Apple Podcasts, and every other podcast channel that I can think of. And so all you have to do is just pop on and search for FLA Law on the radio, and you'll be able to see all our prior episodes. But we are still here for another 20 some odd minutes with Adam Rauman. Adam has been very insightful about estate planning and taking steps necessary to not just protect you, but to protect your family once you pass away. And so if you have questions, this is the time to give us a call. It is 727-441-3000, or you can find us on our Facebook Live page at Pernick, Caulfield, Averill, and Noyes. Pernick is spelled P-E-R-E-N-I-C-H. You can find us there, and you can type in your comments, and we'll be happy to tackle your questions or your comments right there. It doesn't necessarily have to be a question. If you disagree with Adam's assessment about property damage, that's the personal injury attorney and me talking, property taxes, give us a call. We're happy to discuss it. So again, 727-441-3000. But Adam, I know one thing, especially in Florida, that many people are concerned about is the long-term care and being able to afford long-term care as we age or as our family members age. What planning strategies do you recommend for preserving the assets while still being able to address the long-term care needs?
So the best thing somebody can do when it comes to long-term care needs is find an insurance policy that's going to be able to pay for those long-term care bills, because it gets expensive. You're looking, I think at the moment, an hourly rate for a lot of home caregivers is $35+ an hour. Overtime for hours over 40 hours or working on weekends or holidays. So that money can get those bills can get very expensive very quick. If you go into various facilities, those facilities can run anywhere between $5,000 and $15,000 or more a month if you need something like memory care or some additional services. So an insurance policy that's going to cover long-term care is a great thing to have. The other thing that you can do is you can have a life insurance policy where it's a universal or a whole life policy where you can build up cash value in that policy and then borrow back against the policy to help pay some of those bills at a later date. Your homestead's going to be a creditor protected asset. Life insurance, retirement accounts, and annuities are also creditor protected assets. I don't really do the planning specifically when you know mom or dad is going to a nursing care and you're looking to protect those assets. I don't really do that. They refer to that as Medicaid planning. You can do that. They have things that are called personal service contracts, but those personal service contracts are typically with one person. So if you have a family with 3 kids, we can only have a personal service contract typically with one, and that one person is getting paid to take care of mom and dad, which again is helping to preserve some of those assets. But looking at long-term care policies, looking at insurance, again, if you're looking to protect it once you go into the nursing facility, there are certain things that you're allowed to keep that are going to remain creditor protected. And one of those things is that house.
Okay.
If they can afford to pay it, and again, if we get rid of property taxes, it makes it easier to pay for a house that's already paid off. You just got to keep the insurance in place as kids and make sure you're doing some maintenance. We don't have to find that extra money. We can keep mom and dad's homestead there and at least transfer that asset when mom and dad pass away.
I think that's very helpful, and not just long-term care, but I think also what we see a lot in Florida and really throughout the United States are families that have individuals that have special needs, whether it is physical or mental special needs. What can you do as a probate attorney that can address the needs of the family members that have special needs? I think a will is probably not the best way to do it.
No. So if you pass away and you only had a will and you had a special needs child, unfortunately, everything that you own is going to go to that special needs child who may or may not be able to manage the asset. But even more importantly, if you were able to secure some sort of government benefits for that special needs child, they're going to lose the benefits because they inherited money.
Right.
So we can set up what's called a special needs trust. And by doing that, we supplement whatever that child needs for their care. So for example, if that child inherits through that special needs trust, and let's just say we have $100,000 that goes aside for your disabled son, and your son is getting government benefits that covered most of the things he needs. He lives over at maybe a park facility where they have housing for special needs people, but he has some shortfalls. That special needs trust is there to supplement what that child needs so that they get to take trips and pay for extra food or whatever it is they're doing, but we don't essentially blow up the ability to get those benefits from the government, because as soon as you inherit cash, that cash is going to be used instead of the benefits. And then you're going to have to reapply for benefits, which becomes difficult. By setting up the special needs trust, you can continue to supplement what your child was getting, have either a family member or a professional trustee manage that money to make sure your special needs child's needs are being met. And then when the special needs child passes away, that money then goes to other family members. It doesn't have to go to pay back any Medicaid debt or anything else that the government may have.
And I think that's a wonderful way to do it, because I think it's important that the special needs child continues to get the benefits that they need.
And they're difficult to get to begin with. You don't want to lose them.
Oh, I know. And kind of on the same path, but a little bit different. Let's say you're a parent and you have a child that doesn't know how to handle money, that spends way too much and such like that. Are there steps that you can take to protect that child or that person once you pass away from just getting a whole bunch of money and being careless with it?
Well, that's one of the advantages of a trust. So a will and a trust do the same thing. They're going to transfer the assets when you pass away to the people that you want to give them to. The will is public and has to go through probate. The trust is private, does not go through probate. The will immediately hands the assets over. So whether you have a child that doesn't really know how to manage money or you have a child that's under 18, we don't want that child to get a lump sum amount of money at one time. So in a trust, we're able to put strings on those trusts. And, we can put strings in that say, 25% at 25, 50% at 30, and the balance at 35. If the child is older and still can't manage money and you want to be able to give them something, we can tie those funds up for a longer period of time. We can put them on income only. There's a number of things that we can do to sort of restrict those funds. And then, unfortunately, there are people that end up with substance abuse issues. And we have provisions that we can put in trust that say, if one of my beneficiaries is suffering from some sort of substance abuse, instead of funding the problem, we can fund and get help for them. And then when they're recovered, we can then give them the money they need. And if they can't get recovered, then we can keep the money set aside so they don't get it and use the money to continue that problem.
And can that only be done in the trust form as opposed to the will?
Yeah, if you have a will, we're going to hand the money over.
All right.
If it's $100,000 or it's $1 million, they're just going to get their hands on the fund. End of story. If we have a trust, we can put some of those strings in place.
And we've been talking about documents called the will and the trust, but there's also other documents that come into play when we're talking about estate planning or preservation. And I think it's power of attorneys and advanced directives. Can you tell our listeners a little bit about both of those or any other document that I didn't mention?
So you do have a power of attorney. A power of attorney allows somebody to act legally and financially for you. It's valid from the minute you sign it. So it's the one document that I recommend you do not hand out when you make them go back to the attorney and get it from the attorney when it's necessary. As minute you put it in somebody's hand, they can access bank accounts, brokerage accounts, they can buy and sell real property, they can run businesses and do anything you can do. So it's a very powerful document, but it's a very necessary document, because if you get injured and you're in a car accident, you're laid up in the hospital for 6 or 12 months and you can't pay your bills, we want to be able to have somebody pay your bills with your money until you can recover.
Right.
So you can have the power of attorney, we can hand it out, they can use it, you recover, we can revoke it, even if you give that same person the power right back so that they're there just in case it happens the next time. There's also a healthcare surrogate that's going to make healthcare decisions for you. That comes and goes in power. So it's the only document I actually recommend giving to somebody else, because the minute you go under anesthesia and you can't communicate, your healthcare surrogate's there to make decisions. So you go in for a simple surgery, a kidney stone, and they discover you have a hernia and they need to do another surgery. Well, they would need to get authorization for it. They can pick up the phone and call your healthcare surrogate, get the authorization, leave you under anesthesia, do the second surgery, and everything's good. And then there's also a living will. A living will says when death is imminent and you have a terminal condition, end-stage condition, or a persistent vegetative state. Terminal condition is disease-based. End-stage condition, your organs are shutting down. In a persistent vegetative state, Terry Schiavo, you're brain dead, but your brainstem keeps organs functioning. If you have any one or all three of those conditions, you can't communicate, and the doctors have determined that death is imminent. It allows you to say in writing ahead of time, I do not want to be kept alive artificially. I just want to pass away naturally.
And that's called a living will.
That's called a living will.
And too many people get confused between a living will and a will itself.
Yes. So you have.
I wish they named that something else. It would make it easier.
They should have, but it's last will and testament or a will, and then the living will is your end of life wishes with regard to those three conditions. Which I also want to clarify, it's not a DNR or a do not resuscitate. That's a totally separate document you get from your doctor.
Okay. And that's from the doctor, not from the estate planner?
Exactly. You're going to get that from your doctor.
Okay. Well, good deal. So we talked about those. Are there other documents that you address with your clients when you're talking about estate planning?
So those are the 5 documents that everybody needs in an estate plan. Even your kids, 18 years old or older, they need a will, power of attorney, healthcare surrogate, and a living will. They don't have a lot of assets, so we're not really worried about the will. We're more worried about the power of attorney, because you may be paying for their college education, but you can't talk to the school about any outstanding invoices. You can't find out what's going on with anything in school. You've lost all control of your now adult. And so in order to get that
quote unquote adult,
that control back,
as a father of an almost 20-year-old,
a power of attorney would give you that power back. It would let you help them with the banking, find out what's going on with the school, and do those same things that you were doing before. Same thing with the healthcare surrogate. You're not able to make healthcare decisions for your child anymore. So even though your parents, you got an 18-year-old, your 18-year-old got injured, the doctors don't have to listen to you with regard to instructions. They need to listen to the 18-year-old. Now, if they give you back a healthcare surrogate so you can make those decisions, then that's exactly where you need to be. So I draft those documents for kids as well.
I think that's very helpful. I think it's
I say kids, 18, 19, 20-year-old, they're still kids.
They're still kids. Okay, we got about 10 more minutes. So if you have a question for Adam Rauman, just give us a call at 727-441-3000. If you have a question for me, Matthew Noyes, I'm happy to tackle questions as well. And if you have a question that's not related to personal injury or estate planning, or we can get into business law a little bit, still give us a call. We'll be happy to tackle the questions as well. As the host, if I don't know the answer, I get to throw it over to Adam. And if we still don't know, we'd be happy to direct you to somebody that can. But so give us a call now while the lines are still open at 727-441-3000. Now, Adam, at Preservation Law, you don't just do probate and estate planning. You also help small businesses, right?
I form corporations. I help with corporate sales. I do transitions of business from parents to kids. So I do all that business work as well. And that is actually one of the overlooked areas. So you go see an attorney, the attorney drafts the trust and gets you all the other documents in place, but they don't do anything with the business. Well, you own a small business. It's either an LLC or it's an Inc. It may be taxed as an S corp, but that's just a taxing designation. That company is still going to have to go through probate when you pass away unless you do something to put a beneficiary designation on it, which is what I work with companies in order to get done. So I make sure all of the assets that you own can avoid probate in some shape, manner, or form.
I think that's very important. And you're right. It is something that's overlooked too often because they're looking at the homes and the cars and such, but they forget about the businesses.
A lot.
Yes. Well, we do have another caller on the line. Christine, thank you for listening to FLA Law on the radio. How can we help you tonight?
Well, I have probably not a vital question, but I have all right, I'm 73 years old and I'm going to forget the word I want. I have a trust that I moved and I was living in California. Now I need to live in Florida, and the trust is all goes to my son. But do I need to go to a lawyer again and change my address so that my trust is valid?
I think that's a very good question for Chris. I think if I can rephrase the question, if she has a trust that's made in a different state, is it still valid if she moves to Florida? And if not, what does she need to do?
So the good news is if your trust was valid in another state, it is still valid in the state of Florida. That being said, if you become a Florida resident, you've been here for quite a while, I recommend, even with my clients that never leave the state of Florida, that you review and possibly update those documents every 3 to 5 years. So if you've lived in Florida for more than 3 to 5 years and that trust is older than that, it would probably make sense to sit down with a Florida attorney, talk to them about your trust, make sure it's still going to do what you want to do, make sure it has the people in it that you want to have in it, the trustees that will take over the trust when you pass away, and if necessary, go ahead and update it and put in some Florida language in that trust. If you do that, it's called, in most cases, an amended and restated trust agreement. So the trust name will stay the same. We can update it to, if your wishes have changed, we can update it and bring it in with Florida language as well. But it is still valid, so you don't have to go do it.
Like if I died tomorrow, my son would still get my house and
Well, he would still get the house. The question is the house going to end up going through probate? It depends exactly on how the house is owned, which is what we were talking about before with the titling of it. So what I would recommend doing is sitting down with an attorney to go over everything. Make sure you have dotted your I's and crossed your T's, and everything is going to go the way you want it to go. Otherwise, it will go there. It may go through probate to get to the trust and be distributed. And if you're looking to avoid it, then sitting down with somebody to go over that to make sure that you have dotted your I's and crossed your T's is probably the best way to go.
Okay. Well, thank you so much. I was a little concerned about that. So thank you for your information.
Well, thank you for listening, Christine. Thank you for calling FLA Law on the radio. We do appreciate that. I think she and you raise a great point. Just because you do the trust or just because you do the will doesn't mean you're done. You get to forget about it. You said 3 to 5 years. Is that a good range?
Yeah, you should always review the documents. Sometimes you have people in the document that you've fallen out of favor with. You may have named a trustee for the trust that now your kids are older and you don't need that person to be trustee, or maybe you don't even talk to that person or that person passed away. So sitting down to review your documents to make sure they still do what you want them to do is the best thing to do. And there are times that the language in the law changes. So sometimes you need to update for it. Sometimes you don't. Sometimes we have a change in, for example, the healthcare surrogate statute that may require some additional language we put in the healthcare surrogate. So it's always a good idea to sit down and review your documents every 3 to 5 years.
And any major life event, marriage, birth of a child, divorce.
Divorce. Yep.
I think all
divorce.
those need to be taken into account, because what happens? I mean, what happens if you have, let's say, a will? You have a will, and then you get married, and your new spouse is not named in the will. What happens?
So you're going through probate, and you have what's called a pre-omitted spouse, meaning you drafted the will before you got married. Now that your wife or your husband in the state of Florida is by statute entitled to 30% of your estate at a minimum. So depending on what the situation is, if you have kids from a previous marriage, there's a whole lot of things that go into that. So if you just drafted a will and you were giving everything to kids because you were married before, and that's my number one rule. Once you're married and have kids, if you get divorced or your spouse dies, you just don't get remarried. It just makes it a whole lot easier. But if you do decide to get remarried, it does bring up other issues that you need to address. And that puts you in court so that your surviving spouse gets the assets by statute she's entitled to, which again is a minimum of 30%. We'll call it, just for this conversation, 30% of everything you have.
Right.
Including the ability to live in your house for her life.
And your intent may have been that you wanted her to have it all.
Exactly.
But you failed to revisit your will, and that's what happens.
Causes problems.
Yes, it does. I did want to touch base before we end this hour of FLA Law and Radio. I did want to talk a little bit about buy-sell agreements and in the business, and how they relate to estate planning. Can you tell our listeners, in a nutshell, I don't know, buy-sell agreements in a nutshell, but why they're important and how do they come into play for estate planning and succession of business and such?
So if you own a business with another person that's not your spouse, so brother, friend, whoever it is, you want a buy-sell agreement in place. Why do you want that? Because if you or your partner passes away, then the survivor would be in business with your family, or you would be in business with their family, which in most cases, the surviving family doesn't have any idea what you do in that business or how to run it. The buy-sell agreement spells out exactly what's supposed to happen, and we typically fund those buy-sell agreements with life insurance. Why? If you've got a business that is now worth $1 million, $2 million, $4 million, and you want to get rid of your partner's family, then you want to have the cash to buy them out. That's what the buy-sell agreement says. The buy-sell agreement says, if I pass away, you have to pay my family X amount of dollars, and here's the insurance money to do it. My family will sign over the interest in the company so that you have 100% of the company, and my family is getting the benefit of me owning that company. They're getting the cash that they're going to need to live beyond my death.
Just another thing that people don't think about when they're owning business, and what happens should they pass away. So I think that's very important.
In fact, I just picked up a probate for that because two brothers owned a business and didn't have a buy-sell, and now he's going to be in business with his brother's family.
Oh, my
Not
goodness.
happy about it.
Oh, my goodness. And if it's 50-50, the brother's family can stall the whole business process and such like that.
Cause a lot of problems.
Oh, my goodness. Well, Adam, if they have questions after the show, how can they reach you?
So it's Preservation Law Firm. You can go to preservationlawfirm.com. You can send an email to me at adam@preservationlawfirm.com. Preservation, PRESERVATION, lawfirm.com. And you can also reach me at 727-250-0432.
And your office is right in Largo, right?
1920 East Bay Drive in Largo.
All right, Adam, thank you very much for
I appreciate
spending
it.
an hour to educate me and also educate our listeners. We do appreciate that.
Always fun to be here. Thank you.
All right. Listeners, thank you very much. This wraps up another episode of FLA Law on the Radio. I will be back next week, Tuesday, from 5 until 6. My name is Matthew Noyes with the law firm of Pernick, Caulfield, Averill, and Noyes. We are proud presenters of this show. And as I always like to end, drive safely and watch out for those who don't. Take care.